from my standpoint, I know exactly what he's doing in terms of the testing.
Yeah, I think obviously we don't know what would happen if he had reported the next day since he didn't.
Yeah, you're right. He did on one occasion, but then miraculously was unable to give a sample.
I tried. I'm sorry. I don't know why that's blown. Since I was sitting on the bench there and I mentioned I had one kidney, I have to get blood taken quite often. And the only thing I'm starting to think of is that, I know sometimes when they take an excessive amount, they put something else back in, fluids. If that has something to do with it, I doubt it. I never thought about it before, but I haven't drank.
Yeah, from yesterday, they said, I wasn't here Monday. They said, well, she was in on Monday. And it was just a rumor. And I said, okay, so we've had a parony sighting.
like watch that.
That's it. Mr. Bukovich was so happy because he's had to work with Ron Brown.
I'm sure you learned a lot from Brown.
Hell no. I'll take your word. Court does call the case, People versus Andre Thomas. If I didn't say so, Miss Parody, welcome back.
Just this back. I haven't done this in a long time. Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Thomas. Mr. Thomas, state your name for the record, please.
Thomas.
Your Honor, this is a show cause. Mr. Thomas has been in custody since the beginning of June. I think June 3rd. He's being held on a case out of 14A2. That bond is $10,000. So I think he's being.
What kind of case is it?
It was I think it was a stalking case.
Stalking.
Yeah, but I mean,
okay.
So he's being seen by Judge Barr this week. Tomorrow. Okay. So I just asked for another day.
This is show cause he owes what, 410?
Yes.
How long have you been in?
since the 4th.
Or so about 20 days.
Yes.
What I'm going to do, given those circumstances, I'm just going to waive all the fines and costs with the exception of the $125 state fee. And you're all set and done with me.
Great. Thank you, Judge.
Welcome, sir.
Good luck tomorrow.
Court calls case People versus Julia Blevins.
Sherilyn Foster Tucker on behalf of Julia Blevins. Your Honor, I've been in communication with my client. I believe is walking into the courtroom soon, so I would just ask to pass this matter. I apologize, Your Honor.
Like we should wait soon, like it might be sometime.
Should be within the next 10 minutes.
So she took her phone out, looked at her phone, like that gave some credibility to what she was telling me. So you're asking me to pass it?
Yes, Your Honor.
Ms. Perny, should I pass it?
I think so.
Of course you. I knew you'd say that. Fine, I'll pass it. Court calls the case People versus Savannah Bradley.
Good afternoon, people. As a Lauren Perny, Bradley. Bradley's not here. I have attempted to get in touch with her. I have not been successful.
Dan Claire on behalf of probation. Your Honor, Ms. Bradley was scheduled before the full violation of probation, given that she is also non-compliant with the terms ordered by this court. Given the natures of her non-compliance with probation, positive drug screen, criminal offense, another possible pending, and her failure to appear today, probation is requesting that the court issue.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000. I'll give a 10% privilege on that.
Thank you.
Thank you. Court calls the case of the versus Jason Holdaway.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Holdaway. Mr. Holdaway, state your name for the record, please.
Jason Holdaway.
Claire on behalf. Your Honor, Mr. Holdaway is scheduled before the court today for a violation of probation. Mr. Holdaway is not compliant with the terms ordered by the court in that he is not reported to probation as directed. He has an outstanding arrearage of $852 on his payment plan. He's failed to complete his outpatient treatment. He's failed to complete the victim's impact panel. And further, Your Honor, I also provided to counsel, I received a report late yesterday from Community Corrections. Mr. Holdaway, since being sentenced, has remained testing on a sober link. There has been positive blows on that sober link. There was some question because he would report a couple days later and submit to an ETG, which came out as zeros. It's probation stance that Mr. Holdaway is possibly drinking, maybe small amounts, and by the time he's going in for testing, that his body is metabolizing the alcohol that he consumed. I do know, was speaking with counsel late yesterday, and again today, that Mr. Holdaway had indicated that he thought that his reporting to Community Corrections was probation. I can tell you that my office did contact with him, also sending in notification of the violation hearing, which I do give time for a defendant to get into compliance, and there's been no communication from him back to my office with all attempts. Probation's recommendation, which did not include the drinking offense, the drinking events on the sober link, was to remand Mr. Holdaway for 5 days for his violations to date, that probation continue, that he make the payment of the $852 arrears today, then continue with a payment plan of $142 per month, that he report to probation on June 30th at 11 a.m. in person, and that he become compliant with all terms of this court order.
Your Honor, I have had a chance to speak with Mr. Holdaway regarding that. I guess there's two separate issues here, right? The probation issue and then the drinking issue. Regarding the probation, Ms. Pilara is right. He has been reporting weekly to Community Corrections. He's spoken with Agent Mormon. He said on every Thursday.
Yes.
He indicated that he thought that was sufficient for probation's check-ins reporting. He has been living at the Delana Center for about a year. I don't know, frankly, I don't know what how the mail process there is. I obviously know Ms. Pilara sends letters, and I relayed that to Mr. Holdaway. He indicated he hasn't received any letters, but is willing to continue with his probation. He like I said, he has been testing, I think about almost a year since he started this case. He has been reporting to Agent Mormon. So and when this case was pending before he was sentenced, was very communicative with me. So I think he is able, and again, willing to continue on his probation. I'm just not sure where that breakdown happened. He did complete outpatient treatment prior to this case being authorized. I did provide proof of inpatient to Ms. Pilara. We spoke today, and we both don't have that proof of outpatient, but I'm going to work on getting that from Dawn Farm to Ms. Pilara and to the court. Secondly, the drinking allegations. I spoke to Mr. Holdaway. He denies any drinking allegations. I spoke to Agent Mormon, why he would be blowing numbers and then having these negative ETGs. He says he doesn't know why either, just that obviously something's happening before he's blowing. But
Something's happening before he's blowing or before he takes the ETG.
he said I asked, why do you think he's blowing numbers when the ETG is coming back negative? He said he's coming in contact with something with alcohol prior to blowing. The ETG is more sensitive, so I've never seen a situation like this. Typically, the ETGs, come back as positive. And I told Mr. Holdaway, I've never had a situation like this.
When you have low numbers, which these are low numbers on an ETG, what I find interesting, just so that you know where the court's head is at, is had he taken the test the next day, we might have different results.
Can I speak? Sir, good afternoon. I have one kidney and it takes my body times to siphon through alcohol, if you will. And I don't know how the tests work. I don't technically one or the other, but just I'd put that out there. If I were to blow anything, I'm pretty sure it should show up on a P test.
Not if he waits a day, really 2 days. And then if he is flushing his system, it may not show up.
Okay.
But it seems rather strange because on the 11th, well, let's just go back. January 11th, 2026, he's blowing numbers of 0.02, 0.025, 0.19. They contacted him on the 12th, asked if he consumed alcohol, and they requested an ETG test. And I think the date is important. He reported then on the 13th and submitted to an ETG, which is negative. That 2 days. He then, in February 8th, he blows 022, 021, 018. He denied consuming alcohol again on the 8th, but he reports in to take his ETG test. They requested an ETG test. He reports on the 10th. That also then comes back negative. He's then missing some tests in March, and then in April, he blows on April 14th. He blows a 026, 023, 021, 018, and then comes down to a 0 at 11 a.m. They request an ETG test. He reported on the 15th for an ETG test, but was unable to give a sample. He then came in, and again, we're at that 2-day mark, and they didn't do an ETG test. They ran the wrong test on him on that day. Then May, he then again gets alcohol positive test of a 0.05, 0.028, 0.027, 0.023, 0.015. That was on the 25th. They call him on the 26th for an ETG test. He doesn't report to the 27th. That one comes back negative. From my standpoint, I know exactly what he's doing. In terms of the testing.
I think obviously we don't know what would happen if he had reported the next day, since he didn't.
Yeah, you're right. He did on one occasion, but then miraculously was unable to give a sample.
I tried. I'm sorry.
Um,
And the guy who was working there, it was 4:15, and I said, I can finally go, because I drank 15 cups of water sitting there, and he had already left for the day. So I had to come back the next morning. The next morning, they were out of power when I was there at 9 a.m. So I had to wait until 1 o'clock in the afternoon. It was when we had the tornado that touched down in Ann Arbor, and it was that day. And so I ended up taking it at like noon or something like that when they finally opened it up. But Your Honor, I haven't drank. I had my 18-month anniversary on the 4th. And I'm very proud of that. And I mean, those numbers would say that I had a beer or two. That's not in my nature. If there's one, there's going to be 15. So, I'm sorry. I don't know why that's blown. Since I was sitting on the bench there, and I mentioned I had one kidney, I have to get blood taken quite often. And the only thing I'm starting to think of is that, I know sometimes when they take an excessive amount, they put something else back in, fluids. If that has something to do with it, I doubt it. I never thought about it before, but I haven't drank. I mean,
Say the sober league is a breakfast, so it's not like.
The only thing I have to add, Your Honor, is, I mean, Mr. Holdaway he is appearing at community corrections when he's told to. I think that demonstrates some kind of willingness to be a participant, active participant in the case. I mean, he's been blowing for when it doesn't, since July of last year.
for 1,000 of them.
He's been communicating with Agent Mormon. He comes in when Mr. Mormon tells him to come in. Like I said, I think that does demonstrate from running from this. And I will just add also, Mr. Holdaway was housed in the last couple of weeks after living at the Delana Center for about a year. So things are stabilizing for him, which I think is good.
What I'm going to do in this case is I'm going to continue to defend its probation in this case. He is to pay that $852 arrearage as arranged at $142 per month. I'll do that, but he's going to have to arrange to start those payments. He is to report to probation. Ms. Valera, do you have a July 6th time that he could report?
Your Honor, that's not a good date, right? Have the.
Okay, no, that's fine. Any 7? What time? Well, 11 a.m. work. All right.
And that would be me.
I will indicate that the defendant is to report to probation July 7th, 2026 at 11 a.m. in person. Then he's to report as directed. He's to become compliant with all other previous orders and terms of the court within 30 days from the time of his appearance. I am going to remand the defendant based upon the violations to date at this point. Serve 10 days in the Washtenaw County Jail. When defendant is released, he's to be released, but only after a scram tether is placed. Thank you. Courthouse case, People versus Diane Baumgartner.
This is about defendant Nicholas Bukovich on behalf of Ms. Baumgartner, who's now approaching.
I didn't know where to come in.
No, you're perfect.
Your name?
Diane Baumgartner.
Okay.
Teresa Claire on behalf of probation. Ms. Baumgartner is scheduled for the court for a violation of probation hearing. Ms. Baumgartner had drugs to the case back in January of 2024. At that time, the court issued a bench warrant. She was out on bench warrant status for a long period of time until bond was posted on May 20. And then at that time, the court did set this for a violation hearing. Ms. Baumgartner was in contact with my office after the bond was posted, and I had a communication with her. She indicated that she kind of just stopped doing things because she had several serious health issues. She had a couple of heart attacks. She also had appendicitis. So she was recovering. I do know, Your Honor, that the bond was posted in the amount of $500. There's $450 available. Ms. Baumgartner has completed programming and only owes a balance of $449 in this case. Given all circumstances, probation at this time would like to dismiss the violation here and have the court apply the bond to the outstanding balance And also dismiss the case pursuant to the prosecutor deferred discharge on probation.
Maybe asking that the court follow the recommendation of probation in this matter.
Would?
Yes, I would.
You don't want me to lock her up?
No, I prefer you not.
Oh? Why you look that way, Miss Baumgartner? You don't want me to?
No,
No?
no.
Okay, that's okay. I'm not,
Okay.
okay. All right. What I will do is I'll apply the bond to the outstanding balance in this case. I'll dismiss this case pursuant to the prosecutor's deferred. I'll discharge you from probation with improvement and wish you all the best, okay?
Thank you very much. Thank you.
You take it.
Thank you. You too. Thank you. Thank you.
Court calls case People versus Jaden Patrick.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Patrick.
Tracy Claire on behalf of probation, Your Honor, Mr. Patrick was scheduled before the court for a violation of probation hearing, given that he's non-compliant with the terms ordered by this court and that he is not present. Probation is requesting a bench warrant.
The bench warrant will issue for defendant's failure to appear. Bond is set in amount of $10,000, 10%. I'll just Court calls case People versus Brian Culver.
Assistant Public Defendant Nick Bukovich on behalf of Mr. Culver, who is appearing via Zoom.
Sir, please state your name.
Brian Culver.
All right.
At this time, Your Honor, we have reviewed the pre-sentence investigation report. We have no additions, deletions, or corrections. You would ask that the court adopt the recommendation of probation.
Mr. Culver, anything you want to say before I impose sentence?
No, sir.
Sent to the court, I'm going to place you on 4 months prosecutor deferred sentence. You're to pay $480 fines and court costs, $120 probation oversight fees, $25.61 restitution to Walmart payable to the court. When can you get that paid, sir?
The full amount?
Yes.
Oh, okay. I didn't know if you were just referring to the restitution because I had talked to probation about that. I'm a little bit of a financial trouble, so I was trying to use the full time of the probation to get that paid out.
Payment plan is arranged by probation. When are you going to pay the restitution?
Like I said, I think I have to pay it by cash or money order. Is that correct, sir?
That's correct.
So, yeah, just as long as I know where to send the money order, I can do that today.
Okay, the money order can come to the court. Make sure that you reference your court case number. And
Okay,
then probate, and then a payment plan as arranged by probation for the rest. There's to
Okay.
be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to attend individual therapy with verification to probation. There's no going to any Walmart store in the state of Michigan. I'll set a review hearing October 28th, 2026 at 12 noon. I'll order 93 days in jail that is suspended. Okay,
okay,
thank you.
thank you.
Court calls case People versus Cassandra Ormanston.
Teresa Claire on behalf of probation, Your Honor, Ms. Ormiston was scheduled before the court for a review hearing on a prosecutor deferred. She did complete all terms ordered by the court, and I did wait for hearing. Probation's recommended and discharge her from probation.
Hearing no objection, so ordered. Court calls the case People versus Shante Wingard.
Teresa Claire on behalf of probation, Your Honor, Ms. Wingard was scheduled before the court for a review hearing on a prosecutor deferred. She did complete all terms ordered by the court, and I did wait for appearance. Probation's recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge her from probation with improvement.
Hearing no objection, so ordered. Court does call the case People versus Leslie Brown.
This is the public defender monitoring on behalf of Mr. Brown. Mr. Brown, here, Robert, please.
Leslie Brown.
Now, we're here for a show cause. Mr. Brown indicated to me that he would be able to pay about half today. I'm not sure if that payment was made already or not. He also wanted the court to know that he's being sentenced on the 30th to 1 year in our jail. So he will be here for the next 12 months.
Out of what court?
Circuit Court, right, Mr. Brown?
Yes, sir.
All right, so how much can he pay today?
They hit my account, my child support. I can pay 100 today.
Yeah, he's to pay $100 today, then I'll refer the balance to our collections department. So get that $100 in, please.
Okay.
Okay, that's the way we'll. All right, thank you.
Thank you.
Courthouse case, People versus Kyle Jackson. Kyle Jackson. About 1270.
Yes.
Defense warrant will issue for defendant's failure to appear, bond set in the amount of $15,000, 10%. The warrant will issue immediately. Court calls the case People versus Sandra Sanchez.
Assistant Public Defender Nick Bukovich on behalf of Ms. Sanchez, who should be appearing via Zoom.
Ms. Sanchez? This is show cause.
Yes, I'm here.
All right. State your name, please.
Andrea Sanchez.
All right. Show cause CO 726.
Yes, Your Honor. I was speaking to my client. I know she was on a payment plan. However, due to an unexpected garnishment of her wage garnishment, she lost the income she intended to use to pay for these costs and fines. She did make a $40 payment today. She does believe she can make it $50 payments per month to resolve this matter.
50 per month.
Yes.
You paid 40 today. Is that right, ma'am?
Yes.
All right. What I'm going to do is $50 per month versus Robert Downer.
Morning, Your Honor. Governor Michael Vincent, I'm here. Governor. Sir, please come forward. State your name. No, not me. Just.
I didn't hear the ring. Here we go. How's this better? I was sorry to say.
When he got up, I said, that's not Downer.
It's
just like, okay, no, I thought I had lost it. Okay. Your name, sir?
Robert Downer.
All right. Are you having problems hearing at all?
My hearing's a little bit, but I'm fine.
No, we have equipment that.
No, that's fine. No, I'm fine.
Are you sure?
Yeah.
Okay.
It's just when I'm in a big room, it's just.
Gotcha. Well, just so that you know, we do have headphones that will direct all of the sound right.
That's fine.
You're okay?
I am.
Okay.
Thank you.
All right. Not a problem. All right.
Your Honor, no,
Go ahead.
ask me. What?
What?
I'm a lot older than he.
That's because I care about Mr. You want equipment, Mike?
No, I'm
Okay, thank you. All right. Just trying to be fair. Raymond, you're good?
What was that, Your Honor?
Oh, boy.
This is how the day starts. All right. All right. So in Mr. Downer's case, I have a plea form, but before I get to that, there was a motion to suppress. You're withdrawing your motion to suppress.
Yes.
And then I have before me a plea form that indicates that the defendant will be pleading to open intoxicants in a motor vehicle, a 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the.
That's correct, Your Honor.
Is that correct?
Yes, Your Honor.
All right. May I have him sworn?
solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. God.
Yes, sir.
State your name, please.
Robert Downer, DOWNER.
Sir, it is this court's understanding that you are going to be pleading to the charge of open intoxicant. That is a misdemeanor punishable by up to 90 incarceration, a $100 fine plus court costs. You understand that?
Yes,
All right. Understanding all of that, you still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
I didn't hear.
Special rights form.
Did you sign an advice? Okay.
Yes.
Do you have any questions regarding any of those rights?
No, sir.
All right. Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of rights. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty?
Yes.
On the date of December 9th, 2025, at the location of Carpenter and Packard Road in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
And contained in that vehicle, was there alcohol?
Yes.
All right. And do you recall what the alcohol was in the vehicle?
Yeah, was it an empty beer can?
A beer can? And the seal was broken on that beer can?
Yes.
All right. And there was some liquid of some type in that beer can, is that correct?
Yes.
All right. Sir, I do have to advise you that, well, let me do it this way. Sir, I'll just give you those rights. Sir, I do have to apprise you that if between the time of sentencing and the time of my acceptance of your plea, if you commit misconduct under the Michigan court rules, as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence, recommendation, or evaluation. You understand that, sir? Is counsel aware of any other promises, threats, or other inducements which have led to this point?
None.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's plea to count 2.
Your Honor, at the appropriate time, may I address the court?
Yes, and count 1 is dismissed. Yes, go ahead, Mr. Winter.
Mr. Downer, 60 years old, runs a business, never been in trouble. I'm requesting immediate sentencing. I informed him there'll be 2 points on his driving record, and there would be fines and costs attached to this.
We hold just one. What is today? 24. I should know that. It's the middle of Prime Day. All right. My concern, and I don't know, and maybe the people can speak to this, is that the fact, I understand the plea, but the factual circumstance of this case is that there was a 3-vehicle crash of some type. That's what my notes reflect.
Let me double check that. Is 3, I know it was a crash.
There was,
3 people.
Your Honor, he was coming out of the parking lot of all the businesses on Carpenter Road. It was wintertime, had some ice, slid across one car, and then he ended up getting hit by a second car. No injuries, except my client, who spent how many days in the hospital?
15.
15 days in the hospital. No other person was injured.
Okay, I understand all of that. I guess what I'm not getting at is whether or not I would give their claim anything. Are there individuals that may, because of the conduct of the defendant, have a claim to restitution?
There may be the problem, part of the reason that went into this plea and the reason it was offered is because those individuals were never named or identified in the report. So we've had no way to contact them or see what their
Gotcha.
thoughts are moving forward.
Okay, so the individuals involved in the crash were not identified, don't have their names or anything, so.
Correct. Neither their names nor their vehicles were listed in the report or identified. It just says according to witnesses.
Got it.
And to my knowledge, there's been no civil litigation of any kind.
Okay. Then unless there's an objection, I'll proceed with sentencing. Is there anything either you or your client want to say before I do impose sentence?
Other than I represented before, Your Honor, I've got to know this gentleman. Good guy.
Sir, you were taken into custody at some point, right?
No, I was taken to the hospital in the ambulance.
Okay. And were you released then from the hospital or did they take you to jail?
No, I was released from the hospital 15 days later.
Spent a considerable amount of time there.
Got it. Okay. Sir, is there anything you want to tell me before I impose sentence?
Oh, I just hope this is all done and over with. And it's been a bad 7 months as it was, just trying to heal. I mean, I broke everything on my entire body, and it was the worst day of my life that happened.
I'll order fines and costs of $350. I'll suspend 90 days in jail. I'll leave any claim for restitution open for the next 90 days. But we probably.
Did that today.
When can you pay that? Today?
Today.
Thank you. Pay that today out at the counter and you're all set. Thank you, sir.
Yeah, just go down there. Got to wait a little bit for a while to get down.
Take a few minutes.
Yeah.
Okay.
Thank you. I'll call you.
This is so. And this belongs to whom? Who has one? I got it. Never mind. It's in big red letters there. She's here, right? Okay. Court does call the case of the People versus Aaron Williams.
Your Honor, Raymond Cook for the people.
Your Honor, Michael Vincent, on behalf of Mr. Williams. Mr. Williams.
All right. And this is an evidentiary hearing regarding the motion to suppress.
That's correct, Your Honor.
All right. Okay, are we ready to proceed on that?
Yep. Just as a preliminary matter, I believe at the last, the last hearing, the defense asked that the people secure, I believe Angelia Hayes is the witness's name, is the girlfriend of the defendant that the trooper spoke to after the arrest. We were unable to get that witness's appearance today, so I have the trooper, but not that witness.
Mr. Benton, you're aware of that?
I was informed of that this morning.
Okay. Okay. Well, understood. I guess. Do you want to proceed with them not having that witness or? Well, let me ask this. That witness, at least as I understand from the motion, is part of all of this because of her relationship to the defendant.
Yes, and because of statements she made to the trooper after the defendant was arrested.
Right, but she's there. She's there because there's some relationship with the defendant.
Yes,
It's not like she was some person just standing on the side of the road and
correct.
was there.
Was a dating.
Okay,
I think we go forward today.
okay. All right, because I was gonna say that it would seem to me that you might have well, depending on how the relationship turned out, you might have a better shot than they did, but okay, if we can go ahead, we'll go ahead.
Call Trooper Lewandowski.
All right. Trooper, if you come forward and be sworn.
You take seat, raise your right hand. To affirm the testimony about to give be the truth, the whole truth, nothing but the truth.
Yes.
Face for your first and last name.
First name is Hannah, H-A-N-N-A-H. Last name Lewandowski, L-E-W-A-N-D-O-W.
OWSKI. Okay, got it. Okay. Go ahead. You may inquire.
Thank you. Good morning, Trooper. How are you doing? Doing just fine. Thank you for asking. Trooper, how are you employed?
I am a trooper with Michigan State Police. I'm with the Brighton Post.
How long have you been working for Michigan State Police?
A couple, 2 years.
Any previous law enforcement experience? On or about October 30th, so the night of October 30th, going into the early hours of October 31st of 2025, were you on shift that night? At any point in time, were you on or at or near I-94 near State Street? And at around 11 o'clock that night, did you ever have contact with some vehicles on the side of the road? Can you describe to the court what that how that contact began?
So I was traveling eastbound on I-94 State Street when I observed a vehicle, a black Ford Flex, parked on the right side of the shoulder. With a second vehicle, black Mazda, facing the opposite way of traffic. I activated my emergency lights and made contact with the occupants of the Ford Flex.
You said that these were on the shoulder. Were they entirely on the shoulder or were they on the road at all?
They were on the shoulder.
Both vehicles were? And the Mazda you said was facing the opposite way. So would that be westbound?
Correct.
Why did you pull over or why did you make contact with these vehicles?
It seemed like I saw occupants outside of the vehicle, so a car assist I do on a daily basis, so I just make sure no one needed assistance. Me.
Who did you first make contact when you arrived?
I made contact with 2 females. They advised that they were on their way home and they got a flat tire. Upon making contact with those 2 individuals, I learned that both females were either suspected or revoked.
At any point, do you have contact with an individual by the name of Aaron Williams that night? Do you see that individual in the courtroom today? Can you please point to them and identify them by an article of clothing they're wearing? The record may reflect this witness has identified the defendant.
Without objection, record will reflect.
When did you first have contact with the defendant?
I believe it was the initial contact. I observed him walking around the vehicle trying to fix tire.
When you say the vehicle, is that the Flex or the Mazda? Okay. At that time, was there anything about the defendant's demeanor or speech that made you suspicious that he may be under the influence of any sort of intoxicating substance?
No.
How much interaction did you have with him at that time? None? What did you do after you made contact with these 2 females?
After I made contact with 2 females, I returned back to my patrol car, ran them in lean. I then got out of my vehicle, addressed the situation with them. I made contact with the Mazda, which was occupied by 2, was Mr. Williams and Mrs. Angelina Perry, who identified as Mr. Williams' girlfriend.
Did the defendant indicate how the Mazda came to be at that location?
He said he was coming from his home in Ann Arbor and was there to assist his girlfriend's mother.
Did he say who was driving that vehicle? Who was driving, or was driving that vehicle? You said he was coming from Ann Arbor. Did he say when he left to come to that scene?
He said he was just got done watching a football game and was requested by his girlfriend to come to the venue.
Do you remember which football game he said he was watching?
Who? Dolphins versus Ravens?
So
I don't think I like either one of those teams, but whatever.
At what point did you become suspicious that the defendant may be under the influence of either alcohol or some other intoxicating substance?
when I returned back to my vehicle, I requested him to turn the vehicle facing the proper traffic. I returned back to my vehicle just in case I needed to block a lane off for him to do so. When I was in my vehicle, he got out and I observed him unable to maintain his balance with walking the roadway, which made me concerned. I got out, addressed the situation.
When you say walking in the roadway, how far into the roadway did you observe the defendant?
Over the lot line and travel.
And was this before or after he turned the vehicle around?
After.
Okay. You said you addressed the situation. What did you do to address the situation?
I got out of my patrol vehicle. I said, sir, we're walking the roadway. He then came towards me. I was talking to him. And that's when I started smelling odor of intoxicants coming from him.
How close were you to the defendant when you first noticed that odor of intoxicants?
Arms 5 feet away.
At that point, was there anything else about the defendant other than the odor and the walking that gave you reason to believe he may be intoxicated?
I was asking him simple questions and he was unable to give me, he was look at me in the eyes or answer questions I asked him. So based on those observations and indicators, it's when I started to get my reasonable suspicion he was under the influence.
What did you do after you became suspicious the defendant was intoxicated?
I asked him to perform a series of sobriety tests.
Which sobriety test did you have the defendant perform?
3, I had him do the first, the horizontal gaze and stagnus. Second, the walking turn. Third, one legs.
And I'm going to assume the court has familiar with those. I'm going to skip over a lot of the details of those for the purpose of
25 years. Yeah, kind of. All right.
What indicators, if any, did you of intoxication observe during the horizontal gaze and the stagnus test?
Glasses in pursuit, distinct in the same stagnus on a maximum deviation, and onset in stagnus prior to 45. I observed all clues in the defendant and had to remind him multiple times to follow my stimulus.
Why did you have to remind him multiple times? Was he able to follow the stimulus? What was he doing that was unable to follow the stimulus?
Just kept on staring at me, not following my directions or mass.
Okay. So he was looking at you, not the stimulus? What was the next test that you had the defendant perform?
The walk and turn.
And what indicators of intoxication, if any, did you observe during the walk and turn test?
Stepped off line and missed heel to toe several times.
Do you know how many times the defendant missed a heel to toe step? Okay. And what was the third test that you had the defendant perform?
One leg stand.
And what indicators of intoxication, if any, did you observe during that test?
I observed him set his foot down several times and sway while balancing.
What did you do after the conclusion of those tests?
After completing his interview and sobriety test, I requested him to submit to a PPT. In which he refused.
At that point, what happened?
After he refused submitting the PPT is when I placed him under arrest for operating while intoxicated based on my SSTs.
Following the defendant's arrest, did you go back to his vehicle?
Correct.
Were you able to see inside the vehicle at any point?
Yes.
When you looked inside the vehicle, did you observe any containers of alcohol?
I did not know.
What about in the surrounding area? At that point, who all was in the defendant's vehicle?
At that point, everyone was, the 2 females were in the vehicle in the back seat, and then his girlfriend was also in the vehicle.
Did you speak with the defendant's girlfriend about the defendant's intoxication?
Anything, his girlfriend had to say as hearsay. This is a witness, that they had an opportunity to bring to court today, and she's not in court.
Your Honor, I have 2 responses to that. One being that this would go toward, this entire hearing is about the officer's belief and reasonable suspicion. I believe this goes towards her belief in her investigation. And second, I think that this is a preliminary question for the purpose of admissibility of evidence. So I'm not sure if the rules of evidence and the rule against hearsay would even apply at this point.
It's clear here, Your Honor. She,
Well, if it's being offered for the truth of the matter asserted as opposed to this trooper's state of mind and then her subsequent action.
may I address that? Would you
Ma'am?
mind if I sit down or?
No, that's fine if you sit.
Obviously, if the truth or bad is certain, why else would the trooper ask that question?
Well, I mean, I don't mean to make anyone's argument, but I can surmise it this way. The trooper observed certain things regarding this defendant. She then places him under arrest. She's continuing her investigation and she's talking to those witnesses in terms of how she's going to then proceed. So
my understanding that placed under arrest after the girlfriend was talked to.
it's not right.
That's not the testimony that I.
Go ahead. Yes.
I placed him under arrest for operating while intoxicated. I placed him in my patrol vehicle. I then recontacted the.
Yeah. So, I mean, because at that point, I mean, and again, to address your issue, and I know the trooper certainly can speak for herself, but I have 3 individuals now. I have 2 vehicles, but I have 2 of those individuals don't have a valid license and can't operate. So she's got to continue doing something.
I don't disagree with that, but I do believe this is another thing. Certain fact, it's not an evidence. She's not here. And we addressed that specifically the last time we were here to have this witness here. So we wouldn't have to deal with this. And I do believe
But it's not being offered for the truth of the matter, sir. I mean, if the trooper, I might agree with you if the trooper had not placed him under arrest at the time, goes, speaks with her, uses that information then to decide, I'm going to now arrest. I might agree with you, but he's already arrested. So I'm going to overrule the objection. I'll allow it for that purpose.
And do you need me to ask the question again?
Okay.
Did the girlfriend make any statement about the defendant's intoxication that night?
She did.
What was that statement?
She advised that they were both at his residence and that he alcohol prior to driving.
After that conversation, what did you do next?
I informed her that he was arrested for operating while intoxicated. And she advised, which I knew prior, that she did not possess a valid driver's license as well. So I then had to go on the steps to make sure that they were driven home by a valid driver.
Going back to an earlier statement or earlier question, you previously testified that the defendant indicated watching, I believe it was Ravens Dolphins game that night. Do you happen to know what time that game started? I just asked the court take judicial notice that was a Thursday night football game started.
I'd like to object the judicial notice on what time the football game started or anything else about 2 teams I don't give a hoot about.
Well, is that last part of your objection? I mean, but well, I'm a Steeler fan, so I don't like the Ravens, but I think, I mean, I could take judicial note. What would be the relevance of me knowing the time?
It would go to the timing as for when the defendant was driving, because I anticipate there may be an argument that the trooper did not have knowledge exactly when he was driving. And so with the understanding he was watching a football game, knowing when that football game was on gives the court a time frame as to when the defendant would have left the house and began driving.
Okay. I'll overrule the objection. I'll allow it.
believe it was, I put in my motion, let me put up here because I don't have the time. I think it was 8:15 PM is when that game began that night.
Got it. And what time was the stop?
11 o'clock, I believe.
11 o'clock. Got it. Okay.
I can have just 1 second to look at my notes, please, Your Honor.
May I further objection
Certainly.
that because the game started at that time, there's no proof that's what my client watching the game.
I'm happy to address that objection in argument.
I mean, like it was delayed and he's watching it later, or
I don't know what time to sit down and watch. Why this game start? The time starts at 8:15, doesn't mean kick off. I'm not sure what the role of all this is either.
I think it's just to pinpoint there's information that the trooper received that he was watching the Dolphin Ravens game. The encounter on the side of the road is around 11 o'clock. So what the people are getting in and want the court to take judicial notice of is the start time of the game. Now, there might be argument as to what the court does with that, but what weight I should give it, because if it was delayed streaming, I mean, I get your point, but I would still allow it. Certainly, you can argue the weight that I should give it.
My basic argument was the relevancy.
I think it can be relevant, at least as a time frame, so I'm going to allow it.
I think at this point I'd pass the witness.
All right. Cross-examination.
Good morning. What day of the week was this? Thursday? And what was the traffic light at 11 p.m.? Light traffic. And read through the report, and I got the impression as you were pulling up, you saw Mr. Williams kind of walking around somewhat in the roadway.
Not at that point, no.
Okay.
That was. You want me to fully answer? That was after walking the roadway, after I requested him to flip around.
How did you know he was the driver of that car?
Of a monolith.
Yeah. And so you were close enough to ask him that question, correct? And you were how far away from him when you asked him to move the car? A foot, 2 feet? Close, right?
Oh,
And he's in a car, and as you know from your experience, is if somebody's been drinking in a vehicle, it holds the smell, correct? And you were close enough to talk to him, to instruct him, and he was close enough to you to respond, correct? And I noticed in your talk prior prosecutor questions, you never indicated that he slurred his speech, correct? You never indicated that he didn't understand your directions, correct?
sure.
When he's sitting in the car, you ask him to move the car.
It's kind of similar direction.
He understood your directions, right? And there was another person in the car with him, correct? And you obviously should have been able to smell anything on him at that point, right? Because you're right on top of him. Okay, so you didn't smell anything on him? Did you have any suspicion that he might have been drinking?
No.
Yeah, none at all?
Point.
Okay, that's because he didn't slur his speech.
He understood everything you asked him to do. He responded properly, correct? And I noticed in your report that there wasn't any problem indicated. He had to back the car up and then pivot around, correct? He had to turn around. He had to turn the car to face it eastbound.
It's a proper way of traveling, yes.
And I didn't read anything in your report that there was any difficulty him doing that.
He had a maneuver to.
So you would agree with me, he had no difficulty doing that. And it's somewhat of a difficult move, backing a car up on the shoulder of the expressway and then turning it onto the expressway. Now, you did not move your scout car, your vehicle, to block a lane or anything like that. I didn't read that in there either.
Maybe I included, I can't remember if I did or not. I would turn back my vehicle if I.
Okay, but you can't remember whether you blocked the lane or not. If you can't remember, you can't remember. And again, I already asked you a question, but there's nothing in his driving, nothing in his ability to move that vehicle off the shoulder of the road, back up, then make a complete turnaround to face eastbound. Correct? Did he pull his vehicle back up onto the shoulder?
Tires are on the fall line.
He was off the roadway, correct? And you didn't notice any problem with any of this at all to indicate that he was intoxicated?
Correct.
All right. I'm somewhat familiar with the shoulder roads in 94, and they're sloped, aren't they? Not sloped down. So when the rain falls, it doesn't make puddles. It kind of drains off the side. Okay. So what is the shoulder of the road made of? Gravel?
No, it's concrete.
Concrete. This was at night, and he was on concrete, and he wasn't able. Now you saw he wears glasses, right? What did you do about that? Did you have him take the glasses off or leave them on?
I put them on, but I can't recall.
Okay. And you know the glasses would affect the horizontal gaze and astigmatus test, correct? You don't remember that? Okay. And he wasn't able to hold his leg up for any significant amount of time and have to put it down, correct? Did he ever stumble, fall against a vehicle? Did he fall down on the ground doing these tests? Where did you have him do the test? Between the two vehicles on the shoulder of the road?
I have in front of my patrol vehicle.
For your patrol vehicle.
Correct.
And that's with the overhead lights going, correct? And your spotlight is on, no doubt. The bright lights are certainly, your lights are certainly on, correct? So between your vehicle and the flex vehicle, you had them do these tests. The court, can you give me 1 minute?
Yes.
And I noticed in your testimony again, you did not indicate that he was slurring his speech or anything like that, correct?
Correct. Asked and answered.
And
I'll let it go. Go ahead.
And on doing these tests, he understood you gave him directions, correct? And he understood your directions.
I'd say no.
He didn't understand them.
Remind him and ask him numerous times.
Okay. How to do these tests. Would you agree with me? These are not normal tests that people practice every day.
Spills.
Standing on one leg. When you did the walk and turn, you have the people stand in an odd position before they start. Would you agree with me on that? kind of one foot in front of another and have to wait till they're told to move forward?
Correct.
All right. Thank you.
Hey, redirect. I do have a question. So you had indicated they're at I-94 in State, so exit 177. Or let's see. What the heck? There's a lot of stuff I don't know. I don't know why I know that. Anyway, going eastbound, were the vehicles at the Cloverleaf, before the Cloverleaf, after?
We're like just past Ann Arbor Saline. We're at the corner.
So you're, okay, I got you.
We're like
So,
we are in between Ann Arbor Saline and State Street.
so between 175 and State, you're going eastbound.
East.
Got it. Okay. Okay. Was it talked about or was it determined how the Mazda came to face westbound? Was that even? Okay. It was just, that's where it was when you saw it.
Correct.
Okay. All right.
I have no redirect, Your Honor.
Anything else based upon the court's questions, Mr. Benson?
Following up on Judge talked about, it's pretty unusual to see a car up in the shoulder of the road facing the opposite direction.
Yes.
And it would be especially unusual to have this happen around 11 p.m. And you had no suspicion at all that the driver of that Mazda might have been drinking.
Sorry.
You had no suspicion at all that the driver of that, it was a black Mazda, if I remember correctly, you had no suspicion at all that he might have been drinking?
At what point?
At any point up to the moment you encountered him on that 11 p.m. I think it was on the 30th of October.
Sorry. What are you asking? Are you asking if yes, I observed signs of intoxication from this.
Okay.
Are you asking at what duration during my encounter with them?
No, you answered my question.
Oh.
No other questions?
All right, thank you.
No redirect. Thank you.
All right, Cooper, you may step down. Thank you. Any additional witnesses for the?
No, Your Honor.
No witnesses. We have another issue now. You have to file a Frank's motion on the search warrant.
Okay.
Unless the court wants to have us deal with that now. I indicated in my motion, blood test. I didn't go into details.
Right, but I don't.
If the court wants to be on Frank's motion on that.
Well, if it's necessary, I mean, what would be the basis of the Frank's motion?
The Frank's motion, that I'm sure the fact that
Okay, so first of all, I do not have, and now nor was it included in this motion or attached to the affidavit.
then I will draw my.
But typically with the Frank's motion, it's not the exclusion of things in that affidavit, but in the typical fashion, it would be the inclusion of things that may not be true. And then the court would say, well, if that's not true or suspect, and I take that out, is there still probable cause?
I'll file a Frank's motion.
Okay. You know, I think in 27 years, I had maybe 2 Frank's motions. Then Sharon Moore's case comes. And now everybody threatens them all the time. But I'm an expert, so that's okay. Doesn't matter. All right. So you're gonna okay, let's do it this way. Is there any additional argument on this motion?
Your Honor, the only additional argument that people have outside of what was prepared in the written response was the trooper testified that there was no alcohol found in the defendant's vehicle or in the surrounding area. I believe that leads to that circumstantial case that people are arguing that the defendant must have been intoxicated prior to the trooper making contact with him on his way to this venue, and that under MCL 764.15, it was proper for this trooper to investigate and arrest the defendant, even though she never directly observed his driving. For those reasons and for reasons stated in the brief, the people would respectfully request this court deny the defendant's motions.
Your Honor, the vehicle, when the trooper encountered the vehicle, was in a safe position, on the roadway, was not in danger of doing anything. And matter of fact, the trooper thought it was fine for whoever my client built the vehicle. So there's no danger, there's no reason to arrest. One could argue that, but for being told to move the car, you would not have been arrested. Nothing would have happened. But the driving that's involved in this motion was driving that she induced. The trooper told my client to move the vehicle.
Yes, but
that's the driving she saw, and she testified she didn't like the way he looked when he got out of the car. And everything stemmed from him driving that vehicle. What for her asking, excuse me, but for the trooper asking him to move the car and the subsequent actions after that, he would not have been arrested.
But okay, maybe, but I think that you don't go far enough with the but for. Because but for the fact that the vehicle is facing the wrong direction on an interstate, the trooper would not ask him necessarily to move the vehicle.
But she did. But the trooper did. I'm sorry.
Yes, because it's facing westbound in the eastbound lane on a major highway.
I agree. Also, it could have been towed out of there, not by driven. And it wasn't done. And everything that.
But hold on, I get you, Mr. Vincent, but on what basis would the trooper say, I'm just going to tow your vehicle? What she does is, it seems to me, is say, you need to turn that vehicle around so that it's facing a safe direction on an interstate.
I'm not disagreeing with that.
Okay.
But the fact that she did that, everything followed after that. Until she told him to move the car, for whatever reason. Until she told him to move the car, he was not under arrest, even though there's some indication, apparently, that you could smell alcohol on him.
Well, when she's not close enough and he's out of the vehicle, yeah.
But to me, the car facing the wrong way on the expressway on the shoulder road would indicate something's going on. But yet, my point is that none of the testimony about his walking and everything else happened after he was told to move the car and turn it around. And the judgment made, there was no testimony that this was done poorly, any sign of intoxicated driving or anything else, but yet he was pursued on that matter. The vehicle was moved from a position of safety by the trooper. My argument was.
Yeah, but hypothetically, and that's really what you're arguing. One might think that if the vehicle had been facing the correct direction, that maybe the trooper wouldn't have arrested this defendant. But that's not because of anything that the trooper did. It's because of your client having that vehicle face in the wrong direction on an interstate.
I understand, but that, Trooper had an opportunity to deal with all that. Instead, was ordered, told, move your car around. After that,
No, she did have the ability to deal with it, and she did.
right,
By telling him, turn your vehicle around.
and there was no investigation whether he was capable of doing that. No investigation whether he was drinking or not drinking. Nothing like that.
Well, which shows that the trooper did a good job because she didn't make any presumption whatsoever that he wasn't able to operate that vehicle.
Yeah, well, no point arguing the court.
What?
Not arguing the court.
Oh, yes, you are, but it's okay.
Fine.
I mean, I get used to it, but here's the problem, Mr. Vincent. I get what you're arguing maybe, but that the driving or what was observed by the trooper, you're indicating was induced by law enforcement. I say, okay, maybe, except that you don't go back far enough, because if you go back far enough, the trooper encounters a vehicle pointed the wrong way on I-94. And then asks the driver, and at that point, according to her testimony, she's not presuming that he's intoxicated. She doesn't have any belief that he necessarily is. Tells him to turn the vehicle around. He turns the vehicle around, but then she notices certain signs that indicate to her that he may be intoxicated. And it's from that point that she begins her investigation into drunk driving.
The trooper had my client move the car out of a position of safety.
Yeah. Okay, go ahead.
That's my argument.
Yeah, I got you, but I'm not sure that
I'm
a
arguing with
vehicle facing the wrong direction on I-94 is a position of safety. I don't know. I mean, we'll take a look at that, but
anyways.
and the other thing is that you're also going to get into the definition of what constitutes a roadway, because it may very well be, and I'll take a look at it, that the shoulder constitutes the roadway also. I think by definition it does, but I will take a closer look at it.
Wasn't in the lane of traffic. I make that argument.
Right, but the statute talks about a roadway. Roadway under as I'm recalling it, I haven't looked at it. Roadway under the Motor Vehicle Code has a very specific definition, which may include those adjoining parts of the lanes of travel, which would be the shoulder. So it may be that it's in the roadway in any event, but I'll take a look. Okay, so thank you for the argument. How long is it going to take you to file your Frank's motion so that we can?
A couple, 3 weeks.
Seriously? Oh, I mean, okay. Let's see.
Good.
2 weeks. Okay, I'll give you 2 weeks. What's the 24th? Yes. I need the Frank's motion by July 8th. The people's response to that, if necessary, I'm just going to give you 1 week. I don't think it's going to take long. By the 15th. And then I will set a hearing on that Frank's motion, which give me a Wednesday. That's
I would give you July 29th.
well,
Would you like it before then?
I would.
July 22nd.
I can do it that day.
Yes.
All right. Then I'll hear the Frank's motion on July 22nd. And I will issue, if I don't issue it in writing beforehand, a decision on the on this motion. I'll just set a hearing date on that for July 22nd, but it's likely that I will issue a written in prior to that on this. That makes sense.
Yes, just procedurally, because I think I was confused for this hearing, for the Frank's motion hearing date. Does the court want to do an evidentiary hearing that date, or is that going to be set if necessary at a later date? I just don't want to bring the trooper back out again 2 times like I did this time.
Well, except that the preliminary inquiry on the Frank's hearing, while I could hear argument, the court can either typically make a determination that whatever the defendant claims is missing, not missing, whatever, that I could make a determination at that point that I still have probable cause, if you're following what I'm saying. So I'm not sure. I don't think we would necessarily need the trooper, because if the court makes that determination that there's not probable cause, then we would have to have a hearing, or that something, because what Mr. Vincent argued, I'm not sure the trooper's testimony would be necessary. If there's something in that, and just so that it's clear, if there's something Mr. Vincent's claiming that is in that motion or in the affidavit that is untrue, and that the truth of that, well, it could be one of two things. He's claiming something is untrue. If it's untrue, and I say, okay, I'll give you the benefit of the doubt, it's untrue, but I still have probable cause, then I'm not going to need testimony. If, however, the validity of the search warrant would hinge on the truth or untruth of that statement, then I may need the testimony of the trooper.
Understood.
Okay, that's the only way that I can really answer that. Why? The trooper said she doesn't want to come back here? Is that what she said? Was she really critical of, like, it was Alan, wasn't it? That I get. Okay.
My search warrant took 4 corners. So I'm trying to help the trooper not to have to come back, even though I know she's dying.
I know, no, you don't want her back because she doesn't really help you a lot. Just put it that way. I mean, she tells the truth, it just doesn't help you. I will make a determination if we need the trooper back. How about that?
Thank you.
And then we'll work around that. Anything else?
Nothing.
All right, thank you. Thank you, trooper. We still, court stands in recess.
Can one mistake on probation send you straight to jail, even if you swear you never drank? That question became the center of one of the most intense courtroom hearings of the day. A defendant appeared before the judge, accused of violating probation after multiple alcohol monitoring devices repeatedly detected alcohol in his system, but he insisted the results were wrong. According to him, he had been sober for 18 months and hadn't touched a single drink. As the hearing unfolded, probation officers laid out months of monitoring records. Again and again, the defendant's alcohol monitor showed positive readings. Each time, he denied drinking. Days later, follow-up laboratory tests came back negative, creating a confusing pattern that left both sides searching for answers. The defense argued there could be another explanation. The defendant even explained that he only has one kidney and wondered if a medical condition or delayed testing could be affecting the results. But the judge wasn't convinced. After reviewing every test, every date, and every report, he pointed out something that caught everyone's attention. The defendant consistently waited nearly 2 days before taking the follow-up tests. According to the judge, that delay could easily explain why the laboratory results kept coming back negative. The court made it clear that the timing raised serious concerns and suggested the defendant knew exactly how to avoid a positive confirmation test. Even though the judge decided not to revoke probation completely, he also refused to ignore the violations. Instead, he ordered the defendant to serve 10 days in the county jail, continue probation, pay outstanding fines, report in person, and wear a Scram alcohol monitoring tether after his release. It was a clear warning that the court expected strict compliance from that point forward. The hearing ended with one question that still divides opinion. Was the defendant telling the truth about staying sober, or did the judge see through a strategy designed to beat the alcohol tests? Viral title: I haven't had a drink in 18 months. Judge questions defendant's story.